10th, 17th, or 24th.
Today's docket moves fast. Plea deals, adjournments, and bond battles all packed into one intense session. From disturbing the peace charges to critical sentencing warnings, every word matters here. Watch closely because small details change outcomes. Subscribe for more dramatic courtroom breakdowns and real legal insights you won't hear anywhere else.
All right. The plea form indicates that the defendant will be pleading no contest to the charge and added count 2 of disturbing the peace, the 90-day offense. Upon her successful plea to that charge, count 1 would be dismissed. Defendant is agreeing to pay restitution in the amount of $1,607.96. Also, there is a sentence agreement between the prosecutor and the defendant. Sentencing under the prosecutor's deferred with payment of restitution. That is the court's full understanding of the agreement.
That's correct, Your Honor.
Your Honor, there is only one correction I would like to make. I believe we would be tendering a guilty plea without ask of voir dire my client, Your Honor.
Hold on a second. I say that again.
I believe we would be tendering a guilty plea, not a no contest plea, and I would ask if I can voir dire my client on the record when taking the plea.
Okay, because I have the form I have says no contest, and I have the report and have reviewed it, but I don't know. Counsel?
Yes, Your Honor.
So you want to ask her about that?
Yeah, I would, as regards to she's pleading guilty to a disorderly person. I would just like to voir dire her on the record for that. So even if it meant we could do a guilty plea for that, Your Honor.
Okay, go. Counsel.
There was a reason we adjourned last time for a no contest plea.
Correct.
If it's going to be a guilty plea, I don't have a personal issue with that. If that's the defendant's choice, I'm fine with it being guilty plea, but I thought we were doing a no contest plea today.
And if the court would accept it.
If I would accept a no contest?
No, a guilty plea, Your Honor. If we could do a guilty plea on the record here today.
I don't have I'm not going to have a problem. Is that what?
If that's what the defendant wants to do, I'd have no objection to guilty instead of no contest. Right.
Ms. Garcia, do you want to plead guilty instead of no contest to this charge?
Yes, sir.
Okay. You know what? It's Dubin. There's always a first. All right. Ma'am, if you could please raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
Haley Garcia.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of disturbing the peace. That's a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
I do.
All right. And understanding that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
You signed an advice of rights form or had one caused to be signed on your behalf?
Yes, that's correct.
Any question regarding those rights?
No.
You understand that you're giving up those rights, including the rights under paragraph 5, which are your trial rights.
I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily and of your own free will?
That's correct.
And also because you believe that you're guilty of this offense?
That's correct. Yep.
All right. Let me find my, there we go. between the dates of February 22nd to March 22nd, 2025, the location of 2000 Waters Road, that being the Target store. What did you do that makes you think that you're guilty of disturbing the peace?
Your
There's a
Honor,
bat.
Your Honor, it
Hold
would
on.
be okay if I plugged you in my client.
Not a problem, counsel.
Thank you, Your Honor. So, Ms. Garcia, and the date and time that the judge just recited on the record, were you in Pittsfield Township?
Yes.
And at that time, were you in the public?
Yes.
And at that, were you inside Target in Pittsfield?
Yes.
And did you in some way create some type of disturbance or ruckus that you disturbed the peace inside that Target?
Yes.
And did police have to come respond to that disturbance at some point?
Yes.
Satisfied, Your Honor.
All right. Ma'am, I do have to advise you that if between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any sentence recommendation or evaluation, and you would not be entitled to withdraw your plea. You understand that, ma'am?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which had led to this plea?
None from the people?
None from the defense, Your Honor.
All right. And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
March 25th at 9 a.m.
March 25th, 2025, 9 a.m. That's before me.
Your Honor, thank you so much. I really do
All right.
appreciate that. That being said, I appreciate both brother counsel and yourself's patience with me. I do appreciate it very much, and so does my client.
All right. Thank you. Bond will continue.
Thank you.
Take care.
Thank you.
You're welcome, Ms. Garcia. Take care.
You too.
Court calls the case of the People versus Cameron, is it McCrate?
Yes. Carolyn Foster Tucker on behalf of Cameron McCrate. Ms. McCrate, can you state your name?
Cameron McCrate.
And Your Honor, we're requesting an adjournment. I've spoken to Mr. Chabalowski. There may be a couple of videos still outstanding, and we're working towards a resolution as well. Please. Yes.
Public cause conference will be adjourned March 19, 2026, 9 a.m. Bond. All right. Thank you, ma'am.
Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Nympha Romero.
Good afternoon, Your Honor. Randy Cook for the people.
Good afternoon, Judge Larry Margolis, on behalf of Ms. Romero, who is approaching. Please state your name for the court.
Nympha Romero.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to an added count 2 of disturbing the peace, the 90-day misdemeanor. Upon her successful plea to that charge, count 1 would be dismissed. The defendant is also agreeing to write a letter of apology to Deputy Rob prior to sentencing. And there's a sentencing waiver. That is the court's full understanding of the agreement.
That's correct, Your Honor.
Correct, Judge.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Nympha Romero.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of disturbing the peace. That's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. Do you understand that?
Yes, I do.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. And I should advise you that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes.
All right. Understanding that you won't have a trial of any kind, did you sign an advice of rights form?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No.
Doing this voluntarily
Yes.
of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On the date of April 17th, 2025, at the location of 3847 Napier Road, Superior Township, Washington County, State of Michigan, what'd you do on that date that makes you think that you're guilty?
I was not honest to an officer.
Pardon?
I was not honest to an officer.
Okay, you were not honest with an officer, and at some point during that exchange, was there something that happened that was loud and disturbed the peace and repose of the area?
No,
You can say yes.
but I'm not understanding that question, honestly. Because nothing was loud and disturbing.
All right. On the date that you weren't truthful with the officer, did there become an exchange between you and the officer about your truthfulness?
Yes.
All right. And during that exchange, did it get loud to where it might have it might have interfered with the peace of the
Yes.
immediate area
Yes.
surrounding you?
Yes.
Yes?
Yes.
All
Yes, Your
right.
Honor.
Ma'am, if I do accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. Do you understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Judge.
And has the court complied with the court rule?
It has.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be March 24th, 2026, 10 a.m. before Judge Barr. Bond will continue.
Thank you, Judge. Have a good
Your Honor.
day.
Thank you. You do the same.
This exchange is crucial. The defendant initially says nothing was loud, then acknowledges the argument became disruptive. For a disturbing the peace plea, the court must establish actual disturbance. The judge carefully clarifies the record. Without that admission, the plea legally fails. Precision protects the conviction from appeal.
Court calls the case, People versus Barat Shanaman.
Good afternoon, Your Honor. Allison Cass on behalf of Mr. Shanaman, appearing by Zoom.
Your name, sir?
Barrett Shanaman.
All right. What are we doing on this today?
Your Honor, we would be requesting an adjournment as we've not yet received discovery. By my notes, we served the discovery demand upon the prosecutor's office on February 19th.
And you're, I got one moment. On our end for discovery, I have 7 items for sure for evidence.com with someone's email from KD Law Group on 2/5. But on our end, it doesn't show that they were downloaded, so we can resend those.
Okay. Did you hear that, counsel?
Yes, Your Honor. And Ms. Zena, if you could please clarify which email you have down of those KD Law Group.
It was Janice at KD Law Group.
Okay, thank you.
Yes.
All right, but will those links expire? So they might need to be resent?
Well, I'll just resend them to you today.
She'll just resend. Okay, very good.
Thank you.
So I'll adjourn probable cause to March 19th, 2026, 9 a.m. Or as your invite indicates, bond will continue. All right.
Thank you.
Thank you.
Thank
Take
you, Your
care.
Honor.
Court calls the case of People versus Derek Smith.
Afternoon, Your Honor, Raymond Cook for the people.
And good afternoon, Your Honor. With our behalf of Derek Smith, who's appearing via Zoom. Derek, please unmute and state your name for the court.
My name is Derek Smith.
Thank you, sir.
Thank you.
All right, what are we doing?
There's the clean sheet adjournment request in the file, this time coming from Mr. Cook. Discussions are ongoing, and I understand Mr. Cook is needing more time.
That's correct, Your Honor. There's some larger matters that deal with this that I need to talk with my higher up. It involves Arbor.
Involving?
Arbor.
Okay, got it. So Why don't we just go 30 days out? Will that work for
Thank
you?
It will, thank you, yeah.
March 26, 2026, 9 a.m. or as your invite indicates, bond will continue.
All right, very good, thank you.
Thank you. Thank you, sir.
Yep.
Court calls the case of People versus Joseph King Smith.
Andrew Childers, appearing on behalf of the people. Good afternoon, Your Honor. David King on behalf of Joseph Smith is approaching. Joe, can you please state your name for the record?
Joseph King Smith.
All
We
right.
just need a short adjournment, Your Honor. We just have to finalize the deal. So I think the 12th, is that still available?
I don't know what you did to Ann,
What?
because I would have called your case first.
I know, I just.
I don't know.
I thought all of a sudden the rules
I'd
changed. All I had to do was go up and look at Ann and all
I
of a
don't know what
sudden
you did to her.
there's some kind of psychic thing taking place. And I get the next case. I don't know what happened.
All right, the 12th, you think it'll work?
Yes.
All right. March 12th, 2026, 9 a.m. or as your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you. It's on both cases. There you go. I only have one. Court does call the case, People versus Zhejiang Han.
Ellen Glenn on behalf of the people, Your Honor.
Good afternoon, Your Honor. Scott Weinberg on behalf of Mr. Hahn, who also appears by Zoom.
All right, sir, can you state your name?
Zhongxun Han.
Mr. Han, can you state your name, please?
Zhongxun Han.
Thank you. All right, what are we doing?
Your Honor, my client is going to be waiving his right to have the preliminary exam and go to circuit.
Sir, is that correct?
Yes, Your Honor.
And you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
You do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with counts 2, 3, and 4 following. Yes.
Your
Mr.
Honor, may I
Weinberg?
address bond for 1 second?
Well, as to the circuit court arraignment,
We'll waive that, Your Honor.
all right, your client
Stand
stands mute.
Yes.
Defendant having waived formal reading, standing mute to all 4 counts. Court will enter a not guilty plea. Pretrial will be set for
April 21st at 1:30 for Judge Conkey.
April 21st, 2026, 1:30 before Judge Conkey. Yes, Esteban.
Judge, my client lives out of state. He lives in Virginia. He was a student at U of M when this occurred. He has not returned back to U of M. He's on a global tether, and I wonder if the court would entertain to remove the tether. He's had no problems showing up for court in the many times we've been in front of you.
I would object, given the nature of the case, just for victim safety concerns. I know he's currently out of state, but I do have concerns given the facts of this case involving repeated going back to her dorm and the DV nature of it.
Okay, I got you. I'm going to decline to do so. You can bring that up certainly before Judge Conkey when he appears. So I'm going to deny that request. His bond will continue with its condition.
Thank you, Judge.
Thank you. You may. Court does call the case, People versus Jacob Halfacre.
Your Honor, Michael Vince, Mr. Halfacre. Can you come up here and put your name on the record?
Jacob Halfacre.
Thank you.
Judge, I think we worked on a resolution. There's some moving parts that I'm working on getting completed, but I have not been able to complete them yet.
Got it. Okay. So how much more time you guys need?
If you could give us 3 weeks.
Okay. Are you here alone?
Actually, Ellie's watching me on TV right now, so I am not unattended.
Yeah, that's probably true. Will the 26th work for? Yeah, hold on. That made a date. We just have to Check with the people that watch you.
I like this judge a lot.
Notice the tone shift here. This isn't dramatic, but it shows courtroom control. Discovery is complete, dates are negotiated, and the judge subtly manages uncertainty from counsel, even scheduling matters. Efficient docket control keeps cases moving. Behind every calm exchange is strict procedural structure guiding the system forward.
Well, why don't I set it for then? And if it becomes an issue, they'll let us know. Vincent will probably still be trying to get to the door.
Could I have
That was
the new date?
Yes. Probable cause conference will be adjourned March 26, 2026, 9 a.m.
Thank you.
Bond will continue. Thank you. Thank you, Mr. Halfaker. Does call the case, People versus Kenya Tate.
Assistant prosecuting attorney, they have people.
Just put your name on the record.
Kenya Tate.
Okay.
Michael Vincent on behalf of Mr. Tate. Could we approach briefly?
You can. 10th, 17th, or 24th.
Thank you.
Who? Yeah, you're right. No, I got you. Okay, here's what we'll do. Discovery is complete, Mr. Vincent.
Yes, we're ready to go.
All right. So I have the 10th, 17th, and 24th. You don't.
I think 17th is okay.
But you don't know.
I sense it.
This is why they're not supposed to send you here alone. Anyway, here's what I'm going to do. I'm going to preliminary examination in person, March 24th, 2020. We'll just go as far out as we can. They'll move things.
All right.
2026, 9 a.m. That's before me.
That's a 26, Your Honor.
See, 24th, 2026 before me. Okay, don't, you know what, Mike, don't write it down. We'll send it to your office. They already know. All right.
Thank you so much.
Bond will continue. Thank you. Thank you, sir. Right. Oh, he's here. Okay, I didn't see him. Oh. Court does call the case, People versus Dion Lyons.
Yeah, then on behalf of the people,
Did you call him out?
Oh, and good afternoon, Your Honor. Attorney Kevin Bassan, P 71061 on behalf of Mr. Dion Lyons.
All right. Lyons.
Lyons, state your name for the record.
Dion Lyons. All right. Folks, go ahead.
And so, Judge, today is the daytime technically scheduled for a violation hearing. Mr. Lyons has been advised of his right to a hearing. But this time, Judge, we waive that right, Judge, and decline having an actual hearing in this particular matter in terms of having the witnesses testify in terms of bond. Is that correct, Mr. Lyons?
Sir.
You gotta speak up, though.
Yes, sir.
So we would still like to address bond, Judge, and procedurally still set this matter for a preliminary exam.
All right. I do this. So you have all the discovery.
I do, Judge.
All right. People have their witnesses available the 10th.
We'll do our best, sure.
And Judge, the 10th works for me, Judge. I would just ask if possible, Judge, is there any way that this could be scheduled for the afternoon? Is that possible?
can't do that.
'Cause I have an exam that morning, but
I can give you the 17th.
well, the only issue, just his mom is scheduled for surgery on the 12th.
Got it. Yes, I remember.
And the only issue I have is that the other date that you have, the 24th, is that I start a trial at 15th District Court on the 23rd. I start a jury trial on that date.
Who do we have on that? 10th. See, I can't really set it in the afternoon. What? We don't. Okay. I'll do this for you on that count. I'll set a preliminary examination in person, March 10th, 2026. At what time do you think you'll be available?
1, 2 o'clock will be fine, Judge.
I'll set it at 1 p.m. I'll put that before me.
Thank you.
And since I'll be in the building anyway, and that way if the other judges have left, then I'll just take it.
Thank you.
Okay. All right, Esteban.
Esteban, Judge. So I know the court had technically revoked my client's bond as he tested positive for opiates. He's been in custody for a little over a week now. I've had a long talk with my client, Judge, including his family. Judge, he admits that there's an underlying substance abuse issue with opiates, and it's been kind of long standing. I would note that his last test was negative. I can assure the court, since he's had a week to completely dry out with no access to any type of substances whatsoever, that will continue. My client knows that he is to test clean, test negative, and stay clean. He's even willing to work with his family to get any type of substance abuse treatment that he may need. Judge, I can assure this court that there will be no more positive tests for anything, opiates or anything of that particular nature. I think being locked up was a wake-up call for my client, and I truly think he's trying to do the best he can to take steps to stay clean, not only for himself, but for his family and for his daughter. And so, with that being said, Judge, I would ask the court to consider reinstating his bond, giving him one more opportunity to prove himself to the court that he can stay clean, and take advantage of any type of substance abuse help that he may need to do so, And I would also note that apart from testing positive, that on the not the last test, but the test before, that technically there's been no other bond violations whatsoever.
So, just from a technical standpoint, he's admitting to the violation. Then
yeah, and he's admitted to the violation. Correct, Judge.
Young man, anything you want to say before I rule on that? Let me ask you something. Why do you think I locked you up when I saw these results?
I admit I have a problem. So I have a problem, and I admit to it.
Yeah, but there's a deeper reason why I did that.
I don't know.
You don't know? All right. I saw your mother sitting back there. I knew she was here. She's been with you when you come down here, right?
Right.
And the problem with what was showing up on your test, both of those things on those tests can't be true necessarily. All right. What it tells me is that yes, there's a huge underlying problem. The issue for you is that there are drugs being taken that counterindicate or counteract each other. And part of the reason I put you in jail is so you don't end up dead. Because if you take those two things at the same time, that's it. And then mom doesn't have a son to sit there and wait for. That's why I did it. All right. I did it because I believe, despite anything you've done or anything like that, your life has value. And that you're trying to fight something that's hard enough as it is, right? But you're doing it in a way that can end up killing you. Get me?
Get it?
You know, young man, when you've probably seen it before, but when you got taken out of here, your mom kind of looked down. She broke into tears, but she was also, I know, saying that prayer that no one else but a mother could say for her son as you walked out. So consider that blessing that you have. You got me?
Got it.
He's admitted to the violation. I'm going to sentence him to 7 days credit for the 7 days that he served. I'm going to grant your motion. I'm going to reinstate his bond, his previous bond, with all of its conditions, including testing. So you're going to continue to test. Young man, I want him clean.
I will.
All right. Okay.
Thank you very much, Judge.
Thank you. And we'll see you on the 10th.
Thank you, John.
This ruling hits differently. The judge makes it clear jail wasn't punishment, it was intervention. Mixing substances could have been fatal. 7 days served, bond reinstated, strict testing continues. It's accountability with compassion. Like, comment, and subscribe for more powerful courtroom stories and real legal analysis that matters.